Good morning, everyone. We're going to get started here in a brief moment. We just want to see, we've got a couple more people logging in. So good morning, everyone. Thank you for joining us. We will be starting shortly. Good morning, everyone. Welcome to our online presentation on how to review a title commitment and title vesting. My name is Yolanda Hensley, and I am your client services representative here at PRC. I work directly with sales and also in our client services department. Your presenter today is Angel Booth. She is our settlement and sales liaison. Angel oversees account management for all of our clients at PRC. She also works very closely with our settlement teams and is instrumental in assisting with our standard operating procedures for settlement. Angel will be walking you through the basics of how to review a title commitment and title vesting. In addition, we also have with us Jamie Merez. She is our settlement services manager at PRC. She works very closely with our internal title department as well as our settlement teams to administer and ensure our office is operating in compliance with all title and settlement related matters. Jamie will be available to answer questions at the end of the presentation. We're grateful to have Jamie's title and settlement knowledge, knowing that we can rely on her for answers. Due to the time restraints of this course, we will answer all questions at the end of the presentation. We appreciate your patience and understanding. Now, without further delay, let's get started. Angel? Well, good morning, everyone. Thank you so much for joining us this morning. We're going to go over a quick review, do some training on what we're looking for when we have a title commitment and also what we deal with when we have title vesting. Give me one quick moment. I'm going to fix my screen really quickly. Sorry, I have some things showing on the bottom that I don't want to show. All right. Hopefully you guys can see my screens okay. We have questions available if you want to type them in. Maybe we're talking about something and you want to ask a question so you don't forget it. Go ahead and type it in the question box, and at the end we'll go ahead and read those off to make sure we get those answered for you. So we're going to go ahead and get started. How to review a title commitment. We've got some training objectives, and at the conclusion of the presentation, we're going to learn about preliminary title report versus a title commitment, what a Schedule A is, the vesting, and Exhibit A, title clearing and research, requirements and exceptions, mortgages, liens and judgments, statement of information or SOI, solar liens, PACE liens, and federal tax liens. Thank you. I see the question. You can see the screen clearly. First off, we're going to start with a preliminary title report versus a title commitment. These documents are similar and they vary slightly from state to state, but they're pretty much the same. As you can see on the left, that's an example of where you would see where it would reflect preliminary report. And on the right, it says commitment for title insurance. It's pretty easy to spot what these look like. We know on our end, but sometimes there might be question or issue depending on what state you're in, what type of document your underwriter or lender would prefer. And that's pretty standard to see
in California a commitment. So sometimes if you see a preliminary title report come over, for instance, maybe in Oklahoma, you might have an issue because it's a title report and there's things to do with abstracting and needing documents up front that tie into that. But again, if you're getting a commitment for the first time, preliminary title report for the first time, upon review, you'll know right away whether you have an issue or not. We can take care of that fairly quickly. Now we're going to go on to Schedule A. This is also known as the effective date or dated date. The plant date shown on Schedule A reflects the date in which matters affecting title have been examined. PRC requires title updates for all policies prior to closing. So if you look at the examples on the left, it just says dated and it's giving you a date. And on the right, it says effective date. They don't mean anything different outside of that's just the date of information that this title report or commitment is valid. All the information is accurate up until that point. And just as a note, the county recorder can be delayed with their records for a few weeks or a few days even. It's pretty common, nothing that we can control, but we do make sure that anytime we go to closing, we will make sure we get a date down and make sure all of that information is updated and accurate for you. Still on Schedule A, this typically should also include the order, escrow number, as well as the proposed insured, the lender, loan amount, and policy type. This actually helps us quite a bit because I know that sometimes maybe the order is open and the loan amount is provided at that time. Well, if you look on the left, that proposed loan amount is $378,076.96 versus on the right, it's just a flat $100,000. Well, someone would question that on our end. We would say, you know what, let me double check with this processor or this loan officer because I don't think that that loan amount looks correct. It looks like maybe it's the principal limit, not the actual amount they need the loan fees based on. So these are things that we look at as well when we're reviewing the commitment to make sure we're giving you guys exactly what you need up front. Again, sometimes the loan number will be reflected. If it's not provided with the order, it won't be reflected there, but once we do obtain that, any updates to the commitment or prelim we receive, it will show at that time. Still on Schedule A, it will also indicate the nature or interest being covered by the title report, whether it's fee, leasehold, or easement. We've got an example for you on the left, reflecting it being in fee simple, versus on the right, it's showing you that it's fee to parcel 1 and then an easement as to parcel 2. Things like this stand out to us and maybe to you as well when you are wanting to submit your file to underwriting. Just note your lenders may have different requirements for property with interest types other than fee simple, such as leasehold or easement. So if you see this up front, it's going to indicate to you, hey, let me get with my underwriter to make sure we're not going to have an issue, or let me ask title for additional information as to what that entails so we can make sure we jump right on top of that for you guys. Now we're going to go into vesting. The owner and manner in which the interest is held may contain information that affects said interest, such as the trust, life estate, probate, conservatorship, guardianship, or bankruptcy. If there's ever a deceased party, we're going to need to have a copy of the certified death certificate provided to our settlement team as soon as possible so we can start reviewing to see what we need to address the vesting. Upon review, we'll confirm that final vesting based on the state-specific requirements. And as a note, the requirement to obtain an original certified copy of the death certificate, that's going to be specific state by state or even county to county sometimes. We will know once we review that title commitment what those requirements are. So it's always a good measure. If you know you're dealing with a deceased party, make sure you let your team know up front so that way we can start tackling that vesting for you. Now we're going to go into Exhibit A. This is basically where you'll see the complete legal description, and assessor's parcel number will be reflected here as well. This is just a generic example of what a full legal description looks like. And as a note, some states don't reflect the APN in the legal description. It's not something that we can control. If we run a search and the legal description comes back, if it's not reflected there, that's just how that county or state enters their information. So if you guys have an issue ever with that, just let us know. We might have to make an exception and get, title's permission to have it added to the legal description, but it's not something that we control. It's just how the county and state present that information to us. Now we're going to talk about requirements versus exceptions. Requirements are items that must be paid, cleared, or addressed in some way before the file can be cleared or closed. Exceptions, on the other hand, are items that are typically informational and may not need to be addressed to receive a cleared or closed. Each state can vary slightly. However, your settlement team will address these items within the preliminary review sent over with each file. We have some examples here of what requirements will look like. So if you notice, like option number 1 is talking about obtaining evidence of insurance and endorsement types that need to be available, payment of taxes, an owner's affidavit that needs to be completed. These are just items that are all going to have to be addressed before you can move forward, even down to executed mortgage from the borrower in the lender's name with the loan amount. These are all items that must be adhered to before we can move forward. And on the other hand, we have exceptions. Now, these are kind of intermixed. So as you can see, it's reflecting your taxes, the amount, when they're due, your parcel number, things of that nature, even the due date. If obviously there was something due, they need to be paid. So we know that that needs to be verified and paid. But information as far as covenants or easements, that's just information. Nothing necessarily has to be done. If there was something specific to an easement issue or a survey issue, it would call it out specifically and say, this needs to be addressed. But this is more informational versus even item number 7, it's reflecting a deed of trust. So that right there lets you know, well, there's a mortgage on the property. We know we're going to have to order a payoff demand to clear that, to remove that from the final policy at closing. Notes about the terms and provisions, that's just informational. Anything that is of record or needs to be addressed to move forward, it would be a clear indication versus it just simply giving you some information. These are all just standard exceptions that come over on the commitment. Now we're going to go into mortgages, liens, and judgments. Items recorded against the property or borrower for debt will be considered when preparing a title commitment. Liens and/or mortgages can be identified and cleared fairly quickly when the payoff information has been provided up front. It's important to clear title prior to closing to avoid further issues for the current owner, as well as potential issues that could arise for the new lender should there be a need to foreclose. Items of record must be paid and/or cleared to ensure the lender and to also ensure the final policy pursuant to lender's instructions. It is possible for items to show up in the title search that do not belong to the borrower due to a common name. In such instances, a statement of information, credit report, or 1009 may be required. And that gets us into the statement of information, or SOI. When these are required, the borrower will need to complete an SOI to rule them out any liens that don't belong to them. Information required includes prior residences, alternate names, previous jobs, social security number, and date of birth. And this is just an example of what it should look like when you receive this. The settlement team typically will send this over to you at the onset when they're providing you with the title review. It's pretty rare that this requirement will come up after the fact. It does happen. It has happened before, but I would say 9 times out of 10, you're going to always know you need a statement of information up front, and your team will provide that to you up front. Because we're dealing with seniors, it's really important that the loan officer or even the processor is able to assist the borrower just to make sure they fully complete everything. So that way they don't, submit the information and then we have to go back and ask for additional details that were missing from the form. So if you do send this to your borrower and you're going to provide it to us, I'd advise you to just do a quick look over to make sure they filled everything out completely and also legibly, so we're not kind of guessing what's on that form. Now we're going to go into solar liens. A solar lien is a financing statement recorded to reflect the true owner of the actual solar panels affixed to the property. The termination of a UCC solar lien. A payoff will need to be obtained if there is a balance due. There could also be an assessed amount due and payable through the borrower's annual tax bill. Once a copy of the termination is received, verbiage will be added to title confirming the item will not show on the final policy. The UCC termination will be recorded at closing. And as a note, we must confirm if the lender will require the solar endorsement if a notice or agreement is filed. It gets a little bit confusing sometimes with solar liens because a couple of different items are reflecting on title when we're dealing with this. But again, your settlement team is well-versed in how to make sure we clear these properly, and they'll make sure they give you any requirements that we need in procedures on how to do that anytime they give you a title review. And here's an example of what I was just speaking to, the fact that they have a couple of different exceptions that reflect on title, but only the actual lien will be removed once the termination is recorded. Some exceptions could remain on the final policy as indicated. So on the left, the example you see is item number 8 is the actual financing statement, and that's what we're terminating because we're paying it off or maybe there's no balance due, we're terminating that. But the matters reflected below, those items are a public record. Those will likely remain on the policy. It's basically just saying, hey, homeowner, you want to buy this home, we're letting you know there's solar panels on the property. That's all it's doing, it's just giving you information. Now we're going to go into PACE loans. And these are a Property Assessed Clean Energy Program. It's a community loan program that enables financing of energy efficient home upgrades. It's typically paid back over time through property tax bills, and this is another one that can get a little bit confusing here and there just because they add assessment to the taxes as well. So that's something that your settlement team will always make sure that everything is properly paid and will be released in full. So termination of a HERO PACE lien. A payoff demand must be obtained. Your settlement team must confirm if the property taxes are current and also confirm or include any PACE or HERO assessments within the property tax bill. All taxes must be paid in full. To confirm that PACE HERO liens will be removed from title upon recordation of a PACE HERO release. Verbiage will be added to title once the following occur. A payoff is received, a lien release is received, and confirmation that the assessed taxes, which include PACE HERO assessments, will be or are paid in full. And as a note, HERO and PACE programs must always be paid in full. A recorded termination or demand for the UCC financing statement will always be required as well. Now we're going to go into federal tax liens. We just love these so much. If ever there's a federal tax lien reflected on title, the IRS Form 8821 must be completed up front before our settlement team can request a demand. We will always provide this with our prelim review as well. When we review title and we see this is there, we'll make sure we have this document partially completed and provide it to you so that the borrower can execute. Depending on what was provided to us with the open order, we'll fill it out to the best of our knowledge. We should list the tax matters because that's reflected of record and we have a copy of that document. But if we're missing the Social Security number or the borrower's phone number, things of that nature, we can't complete that. So everything has to be completed in full. You miss one checkbox or one line, the IRS will reject it and we'll have to go back to have the borrower complete it in full. So this is another one of those documents where you want to make sure you give it a look over before you provide it back to us, and we'll do the same. And if any information is missing, we'll likely kick it back and just ask for it to be fully completed. That way we don't have a delay because as you can see, the IRS demands take up to 7 to 14 business days to process. And they've gotten better over the years. We've got a good procedure on how to get these ordered, but you just kind of never know with the IRS. So make sure you guys have these filled out in its entirety when you are providing them over to us. Title clearing and research. Once the title commitment has been reviewed, your settlement team will attempt to obtain payoff demands and address any items needed for a clear to close. Taxes will be verified, vesting will be confirmed, and all other items necessary to clear the file will be completed. There may be situations where items reflected on title will require extensive research. PRC will always try to research and clear the issue with the upfront information provided. However, there will be instances where PRC will need the lender, broker, and borrower's help to clear those items of record. As each transaction is unique, PRC will always rely on the assistance of the title department, underwriters, and legal staff to ensure we close our transactions appropriately and proficiently. And now we're going to go over our title review. And this is just the settlement officer's synopsis of important items to address within the commitment. Please always provide all of the documents requested in the title review and contact your settlement team to discuss any possible issues. So here's an example on the right of what you should be seeing when you're receiving the title review. It should go over your vesting, any liens or mortgages on title, and it's also going to ask you to provide the following items, and those can vary on each file. Again, it's dependent on what is provided to us when we receive the order, and also what's reflected on title, what issues we need to address. It'll also go over any additional comments as well, and that will all be mapped out for you with the little review, your commitment, and any documents that you need as well. So we'll take a quick pause and see if anyone has any questions so far. If not, we'll go ahead and move forward. We'll go into our title vesting piece. And again, as you think about things in what you went over today, will you get this presentation? Yes, we actually have audio available of this that we can send over as well. So shoot an email over to our client services, and you'll see that at the end of the presentation on where to request that, and we'll be more than happy to accommodate. Oh wait, let me open up my question box so I can see it just a little bit better. Do you know how to make this bigger? Right here? Oh, here we go. I'm getting to your question, Maribel. I'm trying to open this up bigger. Boy, okay. Why is high liability important to add to title? Okay, that's a good question. Why is high liability important to add to title? It's important because when you're dealing with larger loan amounts, things go into factors such as the credit report, the 1009, loans on title, things of that nature. So when we're looking at factors that might potentially create a high liability, we put that out there. Basically, what's going to happen is underwriting is going to take another look at that file just in case there are any additional requirements. But it's typically listed on anything that's a jumbo or the larger loan amount. That's only time when it comes into play. Hope that answered the question. And I see another question. Oh, okay, great. Do you have a PDF version of this as well? Yes, we do. We absolutely do. And we can definitely talk about being able to share and provide that information. The audio is something that can go out to everyone after the presentation will be available. But just let me know, give me an email specifically, and we can talk about the PDF version. Okay, and it looks like that's the only other question that we had so far. Okay, so now we are going to go into our title vesting. I'm going to give you a quick disclaimer. This presentation is an overview for informational purposes only and not intended in any way as legal advice. Decisions about vesting and how to hold title to property can cause serious legal and tax ramifications. We encourage anyone contemplating matters related to vesting changes to seek the advice of an attorney and tax advisor. Also keep in mind that issues related to vesting vary from state to state, and what may be the case in one state is not necessarily the same in another. All right, topics of interest. With our title vesting portion, we're going to talk about the common vestings and how they differ. In addition to trust and life estates, there are other common forms of vesting such as tenants in common, joint tenants, community property with right of survivorship, tenants by the entirety, and then there's partnerships, corporations, and LLCs. First, we're going to start off with the trust. And basically, a trust allows a settlor or trustor to transfer legal ownership to a trustee to manage the property for the benefit of the beneficiary. The trust must meet state, lender, and title guidelines. Both the trustee and borrower must sign all loan documents. If a trust is ever restated, the vesting must reflect this and should be updated. Successor beneficiaries may be named in the trust agreement, eliminating the need for probate. The trust amendment portion, or the trust restated statement, that's something that is really important. Just to put it into perspective, a lot of these trusts are created years in advance, and a lot of things can happen in between time. So you have to realize that if any changes were reflected and the vesting is not updated to confirm that, that could create an issue, not necessarily a cloud, but it could create an issue because we as title and settlement that we're trying to insure this product, and we say, wait a minute, how do we insure this if there's changes within that trust and the vesting doesn't reflect that? So that's why it's really important to be very mindful of any restatements of trust and things of that nature. So when you're getting your trust or you're dealing with a file and you know it's in a trust, very important to make sure that the borrower provides you the full trust and any amendments every single time. That way we don't have any issues down the line with your loan. Now we'll go into life estate. This is a type of ownership arrangement for real property where the life tenant has the right to use the property until they pass away. Then another person, which is the remainderman, receives the property when the life tenant passes. Life estates can either be granted or reserved in a deed. The life tenant must be our borrower, and the remainderman can be anyone as long as they are 18 years of age or older. Both the life tenant and the remainderman will need to sign the loan document. The first bullet point about the life estate being either granted or reserved in a deed, the being reserved in a deed, that happens quite a bit in some states. It's almost a form of estate planning that I won't say it complicates things, but they're a little bit different only because let me see how I can word this. Sometimes there might be certain circumstances or specific dates that cause that transfer. And a lot of times you'll find that the lender or the underwriter won't necessarily be on board with those reserved life estates. They want it to be, cut and dry, spell it out right there, not, some read between the lines type of situation. So we try to be really good about catching anything that needs to be addressed in the vesting up front, no matter what type of vesting we're dealing with. So if you ever have any questions or you get a funky file and you're like, this vesting looks weird, or I don't want to cause more of an issue for my borrower, I would say just pick up the phone, give us a call and let us talk about it. Sometimes we can figure out a way to give you the best option, or at least get you the advice or point you in the right direction before things kind of spiral out of control. I don't want to get too, pinpoint it, but just kind of read between the lines and know when you're dealing with a life estate, let us be there to help you through those. Now we'll go into tenants in common. This is when you have ownership by two or more parties. The interest can be divided equal or unequally. Each party can transfer his or her interest without participation of the other parties and can leave their interest in a will. Tenancy in common can generally be thought of as the default vesting if two or more names and no other vesting is specified. Then we'll go into joint tenants. This is when you have two or more persons, which are not artificial entities, with equal interest in the property. It usually has the right of survivorship verbiage among the joint tenants, though sometimes certain states require specific verbiage. If one of the joint tenants conveys his or her interest without the others, doing so may sever the joint tenancy, which in essence would create a cloud on title. Community property. This is when you have two people married to each other or domestic partners in certain states. It doesn't necessarily have the right of survivorship. This depends on the state circumstances and whether the deceased party had a will leaving his or her interest to someone else. With a will, it could be that half of the deceased person's interest passes to their surviving spouse, and the other half passes to whom it was willed. Then we have community property with right of survivorship. This is basically the same as community property, but also has the right of survivorship verbiage, and it applies in certain states such as California. I would say it's pretty common to see that in California versus any other state that we've come across. And then we've got tenants by the entirety. This is when you have two people who are married to each other. It usually has the right of survivorship. Sometimes this needs to be stated in certain states. In most states, this type of vesting is the assumption if the people on title are married to each other, and a different vesting isn't specified. In some states with this type of vesting, a judgment against only one of the two spouses won't attach to the property. And then we've got partnerships, corporations, and LLCs. These are what you would consider artificial entities. Partnerships are created by a partnership agreement. Corporations and LLCs are created by filing articles of incorporation with the Secretary of State or other appropriate state agencies. If vesting on file is in one of these entities, the PRC and title settlement team will need to review specific documents to determine what will be required to properly process each file. And I'm going to read you one last disclaimer. This information provided herein is up to date as of November 30th, 2018. Information may vary by underwriter and state. It's always best to check with your settlement officer as to current requirements for specific requirements for any particular file. And with that, I'll open up any questions you might have about those common vesting types. And just like before, you might not think of it today, you might run across a file, and even if it's not our file later and something doesn't look right, you can always reach out to us. That's exactly what we're here for. Don't ever hesitate to question something that doesn't seem right to you. And I'm not seeing any more questions, so basically that wraps up our quick title training. Again, this was just a general training to go over the basics of how to review a title commitment and title vesting. So we thank you so much for your involvement in taking the time to learn with us today. You can always reach out to our client services department directly. You can call us or visit our website. Let's see. I see a question from Dolores. Can we get a copy of this printout? Absolutely. Go ahead and email me and we'll get that processed for you. Just if you notice above, jot down that client services email and you can request it from there. Let's see, I've got a comment from Aurora. You're very welcome. I appreciate that. I'm glad it was informative to you. You're very welcome, Dolores. I had fun with you guys. Next time, hopefully I'll be able to get my video camera to work so you guys can actually see me in the flesh. You're welcome, Maribel. I had a great time. Jamie, I don't know if you're there, if you want to pop in and say hello, hi, and bye to the team as well.
Hi, team. I don't know if you can hear me, but yes, Angel, you did a great job. Thank you for giving all the information.
You're very welcome. I have another question. I have a question on marital status. Okay. And what is your question on marital status? Figure out how to make this box bigger.
And Angel, I cannot see that comment box. Mine's really small, so you can read that
off. I know,
off
it's tiny. We're like, we're clicking just very small to try to open it up. Okay. In some states, does it require a deed? Okay, wait. Christopher, yes and no. So, like, for instance, I don't know, Jamie, if you know off the top of your head where we deal with states where if they're married, like say they're on title and it's just like Jack Smith and Jane Smith, and we know they're husband and wife, sometimes you don't necessarily need a deed to address or change vesting, like say one of them passes away. But in some states, you obviously have to use a deed. Do you know off the top of your head what states those might be?
I do know some states, like state of like Texas, where they might be shown on vesting as husband and wife or just their name. There will not be a deed required, but it's a requirement to show their marital status on the deed of trust. So in those instances, you wouldn't need a deed. But like for California, in order to update the marital status, you do have to add the tenancy with it. We will require a deed in those circumstances. A deed would be required to add the marital and the tenancy.
Gotcha.
But I currently don't know all states, but I do know for sure for an example is Texas.
Gotcha. I hope that answered your question.
And usually the settlement teams will go ahead and email that over. They'll let you know if marital status needs to show on the deed of trust or if a deed will be required.
Right. Thank you, Jamie.
Any other questions from anyone before we go? All right. All right, well, thank you guys so much for attending. Again, if you had any questions after we hang up here, you can always send those over to the client services at prclosings.com email address. You can also request a audio copy, an audio file of the presentation, or the PDF of the presentation as well. So thank you very much for your time today, and we hope you enjoy the rest of your day.
Yes, thank you guys.